Our next case is Jostock versus Mayfield Township. Good morning. This is a 20-minute grant. You have, you may reserve time for rebuttal, but we ask that you keep track of your own time if we don't use it all. And
Good
you may
morning.
begin when you're ready.
May it please this honorable Michigan Supreme Court, I'll reserve whatever time I don't use for rebuttal. I am going to be brief because I think this court wisely issued 4 questions that you wanted answers to, and I think we briefed those responses. I woke up this morning again overweight, but I'm going to run as fast as I can to the language of the statute. I'm not running from the statute, I'm running to the statute, and I believe that the legislature knew what they were doing when they enacted the statute. So in 2006, our Michigan legislature said, we're going to codify the laws regarding local units of government as they regulate development and use. They use those words carefully in the preamble to the entire statute. And then when you move to the statute that we're here on today, we as zoning lawyers all got excited in 2006 for the first time because there was going to be this new tool in the arsenal of zoning, and it was referred to as conditional rezoning. As lawyers then gave seminars on the topic, it began to morph into the term contractual rezoning. So that's set forth in 3405. There is, in that provision, there is no reference, cross-reference, to any other provision of the statute as a whole. It stands alone. And it basically says an owner of land can voluntarily make an offer in writing, it starts to sound like contract, to a local unit of government who's defined as a township, and the township may approve it, meaning they can also say no. So they can approve it or they can say no, and it has to propose certain use and development of certain land. So if I'm a property owner and I want to rezone my property and I want to suggest a use and a development, the local unit of government has the power to approve that. And then in approving it, they can establish a time period as to when I have to get that done. And essentially, the new kicker was that if I don't do what I say I'm going to do in my proposal that they accept, then the zoning reverts back to where it was when I came to the township board. So if you go through section 405 of the statute, I read it as if as the way it sounds. I mean, I take it at its plain language. I take it that the legislature knew they were granting the township local unit of government the authority to grant and say okay to certain use and certain development of certain land subject to conditions. If you don't follow through on the conditions, you revert back to the old zoning. And that's the position I take on the statute itself. Remember, and it hasn't really reared its head in any of the briefs, there's always a backdrop to zoning text amendment processes, and it's set forth in 3402. Anyone is always free to initiate a petition process to gather signatures and take the matter on a referendum to the electors and have it voted on. That's always a backdrop. So then I take the statute and I walk you through very briefly, and then I'm going to be done, is what did my client do? I've just given you my position that I run to the language that the legislature knew what they were doing. This was new to all of us in 2006. This was a new tool. My client got together and we submitted an offer in writing as required. It was very detailed. It laid out what we wanted to be zoned. It laid out what we wanted to do. It laid out exactly what we wanted to develop. It put forth days of use, hours of use, lighting requirements. We did a whole site plan. We proposed exactly two things: our use and our development. The offer was sent by the township to the Township Planning Commission. They set a public hearing with proper notices and mailings to everyone as required for rezoning. They conducted a public hearing on June 10th, 2021. 45 written comments came in and entered into the public record. 19 people showed up and spoke during the hearing process. As lawyers, we were allowed to speak. The township lawyer was allowed to speak. Expert planners were allowed to speak. And at the end, the board deliberated at the Planning Commission level. They have no legislative authority. So they voted to recommend to the township board approval. So their language was, we recommend to the township board that the parcel be conditionally rezoned from R1 to C2 with all conditions in the voluntary proposed agreement presented. And it was a unanimous vote. So they adopted by reference our petition. Then it went to the town.
Has the board ever specifically determined whether or not drag racing is permitted under C2?
I missed the first part of that.
Has the board ever officially determined whether or not drag racing is permitted under C2?
Yes.
Okay, can you point me to when that, or where and
When
that
they
happened?
granted my use. So
So explicitly or implicitly?
Well, let me, if I just finish one comment. So
Sure.
then it went to the township board, and let's take a look at what the township board did. I think is the answer to your question.
Okay.
The township board then puts it on an agenda for June 16th of '21, and it goes to the board, and public comment was allowed, and, you know, it was all okay with the Open Meetings Act, and everything was done right. Motion to adopt the Mayfield Township zoning ordinance number 132. So they're enacting a new ordinance that says I'm okay in that zoning category. For A to B properties to become effective 7 days after publication. And that's the standard process. So then, what happens on June 20th of 2021 is the notice of this ordinance that now says, yes, you can be in C2, and yes, we're agreeing to your terms and conditions, and yes, if you don't do that, you're out. That all goes into the newspaper. And the newspaper reads as the Mayfield Township zoning ordinance, the Mayfield Township zoning ordinance, and the zoning map, dated December 1st of 1909, are hereby amended. They're amending it. It's a text amendment. To rezone the acreage from R1 to C2 pursuant to the conditions in the rezoning agreement that we have executed on May 12th. So they took my agreement that I submitted on behalf of the client, and they executed it, turned it into an ordinance, and adopted the use into C2, published it, and no person triggered a petition, no person garnered up the signatures, and no person tried to overturn this with a vote of the electorate. And so it became final.
Prior to that, are you
No.
saying that it wasn't part of C2?
I'm saying this, I'm saying it wasn't, to answer your question.
Okay.
Because I know you like it when we answer the question.
And
Helps.
council, did anyone challenge the amendment to the zoning ordinance for not following proper process?
No. And I think the Court of Appeals said, we did okay on that. Actually, the trial court said, God bless you, you did very well on procedure. However, what the trial court and what the Court of Appeals said is, yeah, you got it. You did everything right, and you got it to C2. But you're not allowed in C2. But they put me in C2, and if you read the ordinance, they have the authority to put me in C2 and accept the conditions that I proposed. That was the uniqueness of this new statute. So does that answer your question?
Yeah, so basically, you follow process, but they,
Yeah, no, I don't think there's any dispute in the record, and counsel, who often corrects me, can chime in on that, but I don't think we're here disputing OMA or notice or publication or procedure or anything of that nature.
So is it the case that drag racing is now an authorized use in C2? So if I wanted to open up a drag racing track, I wouldn't even have to get any type of special approval?
No. My use on this property, by contract, under
So
conditions.
it's authorized for you?
It's
but not
authorized for me.
But not in the zoning district
Certain
generally?
land has to be my land,
But not
my
in the-
proposal,
So it's not an authorized use in the zoning district generally,
except for me.
except for you?
And that's why we got excited. Zoning lawyers, we don't get excited very often.
You look very excited today.
Especially property lawyers.
Thank you.
Right, you have an audience?
I appreciate my audience left. No, this became a hot topic, obviously, in 2006, because it was a new tool. When we used to do rezonings, we would be coy about what we were going to do, and no one could ask us what we were going to do when we were asking to be rezoned. It was almost illegal.
Why did all the, I don't mean to rain on your parade, but why did all the, about 2006, I know that was a good year, but why did all the amicus groups say that conditional rezoning encompasses only restrictions on allowable uses? If you're right, whenever you're approved, it's allowed, so it doesn't matter. So
Right.
why did they take all the trouble to say that, what essentially is a meaningless?
They actually ask you to run from the language, which is why I made a joke about running to the language. They say, you got to read the whole thing as a whole. He's not reading it right. You know, read it. It says exactly what they authorized. They said, I propose, you can accept. Guess what? You can always say no. I can make a new proposal. You can always say no. I can make another proposal. You can say yes. But once you say yes, you're accepting. It says right here, certain use and development of land. They use those words carefully. They gave the power to accept the use and the development that went with that use on the land. So can somebody else then do a drag? No. Only my acreage can be used for that purpose.
Right. Do I understand your position to be that conditional rezoning under 125.3405 is essentially a contract in which the landowner makes an offer and the zoning authority either accepts or rejects?
Yes. I think it becomes contractual, Justice. I think that.
Under your formulation, then what's the consideration?
The consideration that the municipality receives is the certainty of the use. In other words, they get to listen to, what am I going to do? How often am I going to do it? What are going to be my times? I disclose my lighting, they get to know up front, where they didn't get to know before under traditional rezoning, exactly what I'm going to do on that land.
That's consideration? It seems to me that's something that the local government's giving up.
Well, I mean, if you're looking for monetary consideration or benefits, I think the words morphed into being a contract because the statute uses the word offer, right? Absolutely, and acceptance, or approve. It doesn't say offer and accept. But it sort of became
What does the landowner give up under your theory of this contractual relationship? What is it that the landowner gives up?
The landowner gives up the right to do anything else that might be allowed in that zoning category, and he or she limits himself to the use proposed. And if you stop doing that use, in other words, if my client stopped being a dragway, it's R1 again. He can't then say, well, I'll do something else that C2 allows. No. You're done.
But your client never had the opportunity to do anything in C2 before this, right? Like, are you really giving up something that you didn't have a right to do in the first place?
We were already operating. We operated for years and years and years. We were a lawful non-conforming use in the R1 district. My client gained exit from being lawful non-conforming by being assigned a zoning category C2. with the proviso that I explained to the client, if you ever stop, you're reverting right back to R1. You don't get to pick another use. It's land-specific and it's condition-specific. So when you go to number 2, in approving the conditions, they can set a timeline. And here's the key. There's only one, I only cited to you one Court of Appeals case that has addressed this particular statute. And all they did essentially was give you the cornerstones of what the statute says. And I put it in my brief because it was a published decision. I'm recognizing you're not bound by it, but they said 2 things. Number 1, you have to make an offer in writing. Number 2, the township can't negotiate with you. Those are the cornerstones. I can't put in a proposal and the township says, well, we don't like the days of operation. If you change those, you might have a chance of success. Can't happen. They take my proposal and they can say no. So, but when I turn from the state issue, which I know we're looking at this statewide, and I turn to my own case, look at what I did. I went through the entire process. And still at the end of the day, the rulings have been, no, you're reading it wrong. Here's what you're not seeing, and it's not in the language, is that an owner of land may voluntarily offer in writing, and the local unit of government may approve certain use as long as it's a previously permitted use. It doesn't say that, but that's what the courts have said it says. That's what the trial court says it says. And the Court of Appeals agreed with that, and I disagree with that.
Counsel, could you, I just want to go back to basics, define the difference between conditional rezoning and amending the zoning ordinance? Because obviously you have here, it was R1, it switched to C2 as a conditional use.
Well,
What's the difference?
normally when you rezone, you're amending the zoning ordinance to allow for that rezoning, and you do a map amendment. So here, one of the criticisms that the amicus briefing sets forth, and I think I'm like 0 for 6 on people agreeing with me, right? But anyways, here we are. What happened here is, I think the township recognized that, and they said in their approval, in their publication, we are amending the ordinance. We are amending the zoning ordinance. That's a text amendment. We are amending the ordinance to bring your use that you laid forth in an agreement into C2. And implicitly, therefore, they're saying, we think you belong in C2. Because remember, in zoning, every zoning category has a list of permitted uses, right? A list of uses allowed after special use approval, and anything else that's similar. There's always that catch-all. Because we can't enact a zoning ordinance that lists every possible use, so there's the catch-all, and anything else that's similar. The township analyzed my proposed use. I'm not in their head, but by granting it, must have said, you're similar to the other uses in C2, and so we're going to let you in there, provided you do what you say. How am I doing on time?
2 minutes.
2
2 minutes
minutes.
and 20 seconds.
2 minutes and 15 seconds.
I would stop.
I'm stopping.
Okay.
Taking your advice. Thank you so much, and it was a pleasure to I got a little animated, so I apologize.
Good morning, Your Honors. Your Honors, my name is Adam Flory. It's an absolute privilege and a pleasure to be here this morning. I worked on this matter, Your Honors, with Andrew Concannon, who's one of my law partners and co-counsel on this matter. Your Honors, I will seek to be brief, as I know the court is intimately familiar with this matter, but I would certainly welcome questions at any time the court feels is appropriate. Your Honors, I will move quickly to the court's order and the 4 questions that the court wanted addressed. But I think it was interesting in opposing counsel's argument because I heard something that I had not heard previously. Previous to this, the argument has been that the conditional rezoning agreement served to essentially permit this use at this subject property, the use of drag racing, even though it's not listed in the table of uses under the Township zoning ordinance, sections 1101 and 1102. Now the argument appears to be shifting, and I think Justice Welch's question hit on that, which is now the argument appears to be, no, the zoning ordinance table of uses was literally amended. It was literally amended to add this use, but only for this property, as Justice Viviano engaged. And Your Honors, that's simply not correct. The zoning ordinance was not amended in that way. If the court were to check the zoning ordinance now, it's not amended. And it's never been amended since the hearing in this matter. So that's simply not what occurred. And Your Honors, that cannot occur legally because of the equal dignity provision of our case law. As the court is aware, a municipality may only operate using mechanisms of equal dignity. So if I have an ordinance as a township, I can't change that ordinance by way of resolution. Likewise, if I have a resolution, I can't change it by way of ordinance. In this case, the township did not adopt an ordinance adding this use to the table of uses. The township executed a conditional zoning agreement. A conditional zoning agreement, by definition, cannot amend a zoning ordinance because it does not have equal dignity with the mechanism that it's amending. In other words, an ordinance can only amend an ordinance. If the township wanted to literally amend the zoning ordinance to add a use to 1101, which are the permitted uses, or 1102, which are the uses permitted with a special land use permit, which I'll call a slug, then the township could have done that, but it would have needed to adopt an ordinance to do so. Equal dignity there's a mountain of case law establishing that, and I think that's probably the most non-controversial point we'll have here today. And so the argument fails out the outset for that. A conditional use agreement cannot serve to amend a zoning ordinance. There have to be a subsequent and contemporaneous ordinance to do the amendment. Your Honors, moreover, I would also note that if opposing counsel is correct, then it is the definition of spot zoning. Spot zoning is to have a small zone of inconsistent use surrounded by a larger zone of otherwise consistent use. Every single property that surrounds this property is R1. It's either residential single-family homes or it's agricultural family farms. This would be the only commercial property that exists there. And so for the appellants to say, well, it's only our property, we're the only ones who are allowed to do this, they say that, Your Honors, because they have to. Because as Justice Viviano noted, the township would never want to say that you can have a dragway at any C2 property, because that would be mayhem. A township would never allow that to occur, to have multiple dragways in the property at any of the many C2 properties. And so they're using this legal fiction to say that it's allowed only at this property, which again is the definition of spot zoning. A commercial use utterly surrounded by residential uses on every side. Your Honors, if I may, those were my comments initially on opposing counsel's argument. If I may turn to the court's order to address the questions that the court had raised. Your Honor, the first question was whether 3405 under the Zoning Enabling Act allows for uses not otherwise authorized in a particular zone. And Your Honors, the answer to that question is no. That's the conclusion that the trial court came to, that's the conclusion that the Court of Appeals came to, and that's the conclusion that I believe each of the amicus briefs have come to as well. Your Honor, here is the central point that the appellants are missing. The appellants say, we followed everything in 3405, and you are adding requirements that don't exist. Trial court and Court of Appeals, you can't do that. You're adding requirements to 3405 that don't exist. Here's the point that they're missing. 3405 is an element of Michigan zoning law. It's a part of Michigan zoning law, but it's not the entirety of Michigan zoning law. There's other provisions that also apply. And so it is possible to comply with 3405 and also have to comply with other provisions. 3405 does not abrogate and nullify every other provision of Michigan zoning law. And, Your Honors, the other provisions of Michigan zoning law, namely in this case, is the Mayfield Township zoning ordinance. In the Mayfield Township zoning ordinance, it says in section 1101, here is the list of permitted uses in a C2 zoning district. In section 1102, it says, here are the uses in a C2 zoning district that you may engage in with the attainment of a special land use permit. That's it. It's a closed loop with those two tables of uses.
Counsel, I just want to jump in and ask you the same question. I think there's agreement on this. Was there ever a challenge process-wise to how the conditional rezoning occurred.
So I think that question's a key question, Your Honor. We would not challenge the process of the conditional rezoning, but we would challenge the process of an amendment to the ordinance, because those two are different things. And that's,
So you're saying it was an amendment?
no, Your Honor, I would say that the ordinance was not properly amended.
Okay, so it does seem like there's some confusion over this, over
Yes.
conditional rezoning versus amendment. Okay, let's just assume either one. In the end, isn't the analysis still whether drag racing is allowed under C2, under either pathway?
Yes, Your Honor, I think that's the central initial question, whether drag racing is allowed under a C2 zoning district. Because if drag racing is allowed under a C2 zoning district, then it is ripe for a potential conditional use agreement. And Your Honor, Justice Welch, as to that question, opposing counsel's position, especially at oral argument in the Court of Appeals, was something along the lines of this. If the appellees are correct, if my side is correct, then how would you ever use a conditional zoning agreement? It would never be able to be used. And if I may, just very briefly, I'll present what I would call hypothetical as to how you would properly use it. And this is, Your Honors, I'm a municipal attorney. I've used conditional zoning agreements on dozens of occasions in the past, and this is how you would use it at the dragway. So the dragway is zoned R1. Let's say hypothetically, drag racing is a permitted use in a C2 district, either by right or by attainment of a special land use permit. And the dragway says, we want to become C2 so that way we can engage in the use of a dragway. And the township says, no, we're too concerned about that because it's too much noise and the lights and the fumes and the crowds. And so the dragway says, okay, well, we'll come back to the township and we'll offer this. We'll build these berms to knock down the noise so it doesn't emanate to other properties, or we'll build these sound-absorbing walls, or we'll install certain lighting to ensure that light doesn't go onto other properties, or we will circumscribe our hours of operation to limit crowds. And then the township accepts that proposal and it says, okay, subject to these conditions, you are permitted to operate in a C2 district. We'll rezone you to C2. That's the proper use of a conditional use agreement. But Your Honors, here's the point that's missing under the difference in my hypothetical versus what happened here. In my hypothetical, a drag racing was already a use that was permitted in C2. In this case, it was not. And so, Your Honors, one of the members of the court asked opposing counsel if drag racing, I think it was Justice Kavanaugh, if drag racing was a permitted use in a C2 district. And opposing counsel's answer was something to the effect of yes, because of this conditional use agreement. So I believe we all agree then that prior to this, drag racing was not permitted at all in a C2, and other than the conditional use agreement, drag racing is not permitted. Of course, we don't feel it is permitted even with the conditional use. But their position is only that drag racing is permitted by virtue of the conditional use agreement. And that's central to the court's question, question 3, of whether the operation of a dragway is an authorized use. Some of the amicus briefs have tried to fit the prospect of a dragway into other uses in a C2, and with respect to the amicus briefs, it's not a fit, and the township has already found that it's not a permitted use, and that's why we're here. That's why it was done in this way. One of the amicus briefs noted that, well, it could be an open-air business. Well, the two examples that are given in that subsection, which I believe is 1101 subpart 8, are plants in nurseries where flowers are grown in greenhouses. That's about as far from a dragway as I really can think, a greenhouse versus a dragway. Another, and I believe that example was from the Michigan Township Association. I believe the MML noted perhaps automobile service facilities. Well, again, the zoning ordinance in section 1101 goes through and provides examples of what that is. An automobile service facility is like a garage where cars are repaired. That's not a dragway. You don't get loud emanating noise from engines running at a garage, or lighting issues, or crowds of people, hundreds of people.
Well, you could, though, at a children's amusement park, right?
Theoretically, yes, Your Honor. You could get crowds at a children's amusement park, certainly.
And that's one of the defined examples of C2 usage, correct?
I believe that's correct, Your Honor, but again, I would respectfully submit that a children's amusement park is far from a dragway. And I don't think anyone, including opposing counsel, would suggest that either of those uses are analogous. And again,
I'm sorry, can you said something earlier where you said the township, I understand, he said that because of this conditional use agreement, the township, at least implicitly, now says it's part of C2, and I think he did say that before that it wasn't. You said the township already decided that it is not a permit, it's not allowed under C2. When and where, or what can you cite me to that I can, where I can look and say, okay, yes, the board decided
Your
drag
Honor,
racing is not a permitted use under C2?
Yes, Your Honor. Thank you for that question, Justice Kavanaugh. And, Your Honor, I'm basing that upon the litigation that's occurred in this case. There's been litigation in the trial court. They've never taken the position that it's a permitted use, that anywhere in C2. That's never been discussed, ever.
So you're both, if I may, like sort of saying implicitly, because he's saying how they decided it, the way he's interpreting it, it is now, and you're saying, well, they never did. Like, we don't have a determination specifically by the board saying whether they think drag racing is permitted under C2.
Well, Your Honor, I would say two things in response to that. Number one, it's not uncommon for us to be in the position we're in because townships don't make a habit of making findings of what's not permitted. So they're not going to hold a hearing and say, you know, here are the uses that are not permitted. That's just not something that's going to occur. At any part of this litigation, it would have been very harmful to our case, my side's case, if the township or any party would have said, no, look at 1101 subpart 6, drag racing's permitted. And no one did that. The township never did that, opposing counsel never did that, his party, and that's because it's not permitted. And Your Honor, the second part of that is, I would simply say, with respect to the township, we don't need them to say that one way or the other. We can look to the zoning ordinance itself. There's no provision under either 1101 or 1102 that's even close to dragways.
Well, but we as a reviewing court give deference to a board's interpretation of their ordinance, right? So if they never do it, and I think it's at a minimum debatable, or let's say it is debatable, you know, where don't we need the board to decide that and then for us to review that?
I would respectfully say no, Your Honor, and for a couple of reasons. Number one, the appellant in this case had that opportunity. You can petition a zoning board of appeals for an interpretation of a zoning ordinance. They did not. That's a provision under the Michigan Zoning Enabling Act. If they wanted to do that, if they wanted to seek out that opinion, they could have, and they did not. And so we've gone through at this point years of litigation, and they should not be rewarded at this point and given essentially another bite at the apple. Early in this case, they could have pursued that avenue, and they chose not to. And so, Your Honor, I would respectfully submit that they should be held to that strategical decision. Moreover, Your Honor, your statement regarding deference to the local authority is absolutely correct. We absolutely give deference to local municipalities. Having said that, Your Honor, if we look at the table of uses and we can't find anything that's remotely like a dragway, then we do not need to remand this to allow for that interpretation. And I think it's key that we're all pointing at different things. Justice Welch raised the issue of a children's amusement park. One of the amicus talked about an open-air business like a nursery for plants. Another business talked about automobile service facilities like a garage. That's because it's not there. And so we're all we're all independently thinking, well, maybe it could go here. I don't know. Maybe it could go there. And it's simply not there. If the clearest way, as this court knows, to derive legislative intent is to look at the language of the legislature. In this case, the legislature is the township board. If they intended for a dragway to be permitted either with a SLUP or as use by right, they would have said that. And they could have said it easily. There's a dozen different ways they could have made that clear in the zoning ordinance, but they did not. So with respect, Your Honor, I would simply say that I think they have explicitly said that it's not permitted by virtue of the zoning ordinance. Again, it's not common practice for a municipality to specifically list what's not permitted. They'll list what is permitted, and what is permitted does not include a dragway. And that's clear under 1101 and 1102 of the zoning ordinance. Your Honors, I just want to make sure I address each of the questions. So again, moving on to, I addressed question 1, which is that 3405 does not allow uses that are not otherwise authorized. All of the amicus agree on that. The Circuit Court agreed on that. The Court of Appeals agreed on that. And again, that's because 3405 cannot abrogate every other aspect of Michigan zoning law. We still have to comply with the zoning ordinance and those table of uses. 3405 does not entitle a litigant to seek refuge under that statute and say, I don't have to comply with anything else. 3405 I complied with, and so I don't have to comply with anything else. The zoning ordinance or any other aspect of the Zoning Enabling Act. That's not what it stands for. Question 2, Your Honor, is what mechanism was used to authorize the dragway? Your Honor, just quickly on that, that mechanism was a legal nonconforming use. Your Honor, there's much litigation around this dragway. There's another separate litigation right now currently pending in the Lapeer County Circuit Court where we are taking the position that the dragway, use of the dragway has been terminated by destruction because of significant repair was done on it at a time. It's not germane to this analysis. I simply say that to say we would not agree that it currently is a lawful nonconforming use. But for purposes of this argument, if we say it is a lawful nonconforming use, that is the mechanism under which it exists. And, Your Honors, my time is limited, so I won't go through the dozens of cases I could cite that I have in my outline, but this Court's well aware that lawful nonconforming uses, number one, can never be expanded. We cannot expand a lawful nonconforming use, and lawful nonconforming uses must be eliminated at every turn wherever possible. Wherever legally possible, it must be eliminated because the ultimate goal is to have full compliance with the zoning ordinance. In this case, by virtue of an erroneous, what I'll call paper decision, the township eliminated, in quotes, eliminated the nonconformity, so to speak, but they did not eliminate the use. It's the use that must go away, the use of a dragway, because we want similar uses together. That's the point of zoning. We want residential uses together, agricultural uses together. You do not eliminate a nonconforming use by rendering that use permanent, and that's what they did here. That's as to question 2, Your Honors. Question 3, Your Honors, is whether operation of a dragway is an authorized use under C2. I think I've discussed that at length, and again, the answer is no. There's nowhere in the tables of uses in 1101 or 1102 that come close to authorizing a dragway, and no one's made that argument. The opposing counsel did not make that argument at the Court of Appeals. The Court of Appeals did not find that. The Circuit Court did not find that. Actually, at page 36 of the appellant's brief, they state that it's not permitted. Page 36 of the appellant's brief, Your Honor, the appellants state, quote, a careful examination of the township zoning ordinance reveals that a dragway was not previously expressly listed as a permitted use under C2 zoning prior to the conditional rezoning contract. So they acknowledge it was not listed. So there's not even an argument there.
Well, is it just, if it's not listed, it's not included? I mean, the zoning ordinances are written such to say other like uses, right? Or I'm paraphrasing, right? So agree, everybody agrees you can't list everything possible, and you're not going to opine on what's not included and all that, which is why zoning ordinances are written to give examples and then sort of couched in terms of these or other like uses. So saying it's not specifically listed isn't particularly remarkable, right? Because we could look at that and see that for ourselves. The question really is, and what amicus bring up, does it fall, could it be under an analysis of the other similarly, like uses be considered a permitted use?
Yes, Your Honor. I realize my time has expired. May I respond?
Please.
Thank you, Your Honor. Your Honor, I would raise a couple of points. Number one, that's not the argument that opposing counsel makes. They don't say, well, it's not permitted, but it's not expressly permitted, but it is implicitly permitted because it's similar to these other like uses. They don't make that argument because they know it's not permitted. And again, every level, Circuit Court, Court of Appeals, amicus, us, every level has realized that it's not permitted. And so I would respectfully submit that they've foreclosed that issue. They've given that issue up in their brief at page 36. But to directly address, Justice Kavanaugh, your question, you're correct that you cannot list every conceivable use. And you're correct that the zoning ordinance says other like uses to the uses that are listed. The problem for the appellants in this case, and the problem for the township in this case, is that the use we're talking about, a dragway, is not similar to other like uses. A dragway is not similar to a plant nursery. A dragway is not similar to an automotive repair facility. It's not similar. And there are other uses that they could have listed to make it similar. I would also state, Your Honor, and I state this as a municipal attorney who I draft zoning
Very
ordinance.
briefly, because your time is up.
Ordinances for a living, that when a use is more intense than not, those are the uses you would explicitly state. So uses that are less objectionable, sure, maybe you rely on some implicity there, that you can fall under the catch-all of other like uses. But for an intense use like a dragway, that's a use that if they intended to permit it, they would have stated that explicitly, and we must rely on the clear statements of the legislature in their zoning ordinance. Your Honors, it's been the privilege of my career to argue before you this morning, and I thank you very much for your time.
Thank you.
Very briefly, I ask that you carefully read 3405 and try to find the language that says it has to be a permitted use. The legislature knew what they were doing here, and I'm running to that language strongly. Justice Kavanaugh, we all know that courts don't sit as super zoning authorities. We elect local officials. We allow them great deference. By saying yes to my proposal, by saying yes, we approve your offer, implicitly they were saying, after they ran it through the Planning Commission, implicitly they were saying, we think your use and your development fits in C2. And when they went to publish, they published it that there would be a text amendment to the ordinance adopting my agreement. So they, you know, what was in their head? I don't know. You know, do you know? We don't know, but we have to give deference.
Counsel, just a quick question, and good morning.
Good morning.
Good morning. Is there something specific to drag racing? Like, is there something unique to that, which is what's causing some of the concern? Would you stipulate to the fact that, you know, this presents a unique set of facts and circumstances that can be problematic?
Well, I put all of those issues into my offer.
Right.
Okay, so let's go through them, and it's a great question. Can the dragway cause noise? Yes, so I addressed the noise in my proposal.
Right.
Can lighting be an issue? Yes, so I addressed it in my proposal. Can days and hours of operations and holidays be an issue? Yes, so I put it in my proposal. I tried to address in our offer all of the issues that could be unique to a dragway. But we have 56 acres, and we have a lot of sound buffering, and we have a lot of distance before we get a residential unit. So I understand the question. Yes, I would say dragways can cause noise, light, and disruption, but we tried to address all of that, and they said yes. Remember, they can say no. They could have just said no. It's within their purview under the law to say no. They didn't have to approve this, but they did. And I followed all the rules, and then the court system said, well, you missed a requirement. There's a requirement that you have to be a permitted use. I don't see where it says that. Thank you.
Thank you. Thank you both. The case will be submitted.